Former President Donald Trump formally appealing the decision by Maine's Secretary of State to remove Trump from the primary ballot there. Now, in Maine, election challenges are often first ruled upon by the state's top election official. And last week, Secretary Shenna Bellows ruled Trump is ineligible to appear on the state's primary ballot based on the 14th Amendment, the same statute Colorado's Supreme Court used. The appeal of her decision will be heard by the state's Superior Court. A new filing from the Trump legal team accuses Bellows of prejudice in her decision. Quote, the secretary was a biased decision maker who should have recused herself and otherwise failed to provide lawful due process. The court has until Sunday to decide whether to overturn Bellows' ruling. That decision can be appealed all the way up to the U.S. Supreme Court. And Secretary Bellows joins us now. It's good to have you on the show. We appreciate your joining us. I have a couple questions to start with here. Good morning. Can you explain for our viewers what you decided on, the issue of eligibility? What does that mean? Who does it apply to beyond the former president, in your opinion?
So it's important to understand that Maine law is unique. Now, of course, under Article 1 of the Constitution, the states have the authority to administer elections, and states have different processes, different election laws. Here in Maine, under Title 21A, for the legal geeks out there, the legislature has delegated authority to the Secretary of State to ensure that every candidate meets the qualifications of the office that they seek before placement on the primary ballot. And under the law, so first I accepted Mr. Trump's signatures, qualified his signatures. Any registered Maine voter can bring a challenge to those qualifications, which 5 registered Maine voters did, including 2 former Republican state senators, 1 former Democratic state senator. I'm then required under the law to hold an administrative hearing. It's an adjudicatory hearing. Both sides can have attorneys, and did in this case, present evidence, witnesses, engage in cross-examination. And then based on the evidence presented in the hearing and the law, I am required within a week of the conclusion of the hearing proceedings to issue a decision. Now, the next step is Superior Court. Mr. Trump, of course, has appealed. That's the process. That's the rule of law. Then it could go to the Maine Supreme Court and then, of course, the U.S. Supreme Court.
And then the decision was made. My understanding, it's not about whether like a crime was committed, the crime of insurrection, but engaging in insurrection. Can you explain that? Because I think a lot of people, especially Trump supporters, are saying this is political. Donald Trump himself is saying certain things about you and your prejudice. Can you explain the decision and how it pertains to insurrection?
I swore an oath to uphold the Constitution, and my requirement delegated to me by the Maine legislature is to ensure that candidates meet every qualification. So, for example, with presidential qualifications under the Constitution, I am not permitted to allow an 18-year-old or a non-citizen or Barack Obama or George W. Bush to be placed on the ballot. Section 3 of the 14th Amendment has never previously been evaluated. I'm mindful that there's no precedent for a Secretary of State to deny ballot access to a presidential candidate for engaging in insurrection. I'm also mindful that no presidential candidate has ever engaged in insurrection. But if I may, the text of the 14th Amendment is particularly important here, and I'll quote, "No person shall hold any office, civil or military, under the United States, who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." That's Section 3 of the 14th Amendment of the Constitution. And under the authority delegated to me, I was required to hold a hearing, required to issue a decision. Now it goes to the courts, the Superior Court, then the Maine Supreme Court and the U.S. Supreme Court will make a determination, and I will uphold the rule of law. I will follow whatever the courts decide. That's my obligation.
Can I just ask, has your life changed at all since you made this decision? Are you getting any reaction, like personally, from either side in this fight?
So I'm heartened by the amazing positive reaction that I have received from people, including people who disagree with my decision. A former Republican legislator who told me candidly he disagrees with me, he supports Trump, but he came by yesterday with some relish and some jam to give me a hug. So that type of support, that respectful civility that marks Maine has been really encouraging. But I also have been deeply concerned at the aggressive, abusive, and threatening communications targeting my staff, my family, and indeed, on Friday night, my home was swatted. Now, my husband and I were away for the holiday weekend. Law enforcement has been perfect. They acted completely appropriately and were in great communication with me. So the incident happened without incident. But just because it was fake and swatting is a fake call doesn't make it any less dangerous. And these types of attacks need to stop. The proper process is to follow the rule of law. And that is what I have done. I have done my duty under the Constitution, and it is now in the hands of the courts. And then I will implement whatever the courts direct me to do. That's what we do in a democratic republic. That's what makes our country, our nation, so great, so powerful, as we are a rule of law. And these threats of intimidation, these political attacks are really unacceptable.